5. Land acquisition, restrictions on land use, and involuntary resettlement. Introduction. Paragraph 1. Environmental and Social Standard 5 recognizes that project-related land acquisition and restrictions on land use can have adverse impacts on communities and persons. Project-related land acquisition or restrictions on land use may cause physical displacement, that is, relocation, loss of residential land, or loss of shelter. Economic displacement, loss of land, assets, or access to assets, leading to loss of income sources or other means of livelihood, or both. The term involuntary resettlement refers to these impacts. Resettlement is considered involuntary when affected persons or communities do not have the right to refuse land acquisition or restrictions on land use that result in displacement. Paragraph 2. Experience and research indicate that physical and economic displacement, if unmitigated, may give rise to severe economic, social, and environmental risks. Production systems may be dismantled. People face impoverishment if their productive resources or other income sources are lost. People may be relocated to environments where their productive skills are less applicable and the competition for resources greater. Community institutions and social networks may be weakened. Kin groups may be dispersed, and cultural identity, traditional authority, and the potential for mutual help may be diminished or lost. For these reasons, involuntary resettlement should be avoided. Where involuntary resettlement is unavoidable, it will be minimized, and appropriate measures to mitigate adverse impacts on displaced persons and on host communities receiving displaced persons will be carefully planned and implemented. Objectives: to avoid involuntary resettlement, or, when unavoidable, minimize involuntary resettlement by exploring project design alternatives. To avoid forced eviction. To mitigate unavoidable adverse social and economic impacts from land acquisition or restrictions on land use by A. Providing timely compensation for loss of assets at replacement cost, and B. Assisting displaced persons in their efforts to improve or at least restore their livelihoods and living standards in real terms to pre-displacement levels or to levels prevailing prior to the beginning of project implementation, whichever is higher. To improve living conditions of poor or vulnerable persons who are physically displaced through provision of adequate housing, access to services and facilities, and security of tenure. To conceive and execute resettlement activities as sustainable development programs, providing sufficient investment resources to enable displaced persons to benefit directly from the project as the nature of the project may warrant. To ensure that resettlement activities are planned and implemented with appropriate disclosure of information, meaningful consultation, and the informed participation of those affected. Scope of application. Paragraph 3. The applicability of Environmental and Social Standard 5 is established during the Environmental and Social Assessment described in Environmental and Social Standard 1. Paragraph 4. This Environmental and Social Standard applies to permanent or temporary physical and economic displacement resulting from the following types of land acquisition or restrictions on land use undertaken or imposed in connection with project implementation. A. Land rights or land use rights acquired or restricted through expropriation of other compulsory procedures in accordance with national law. B. Land rights or land use rights acquired or restricted through negotiated settlements with property owners or those with legal rights to the land, if failure to reach settlement would have resulted in expropriation or other compulsory procedures. C. Restrictions on land use and access to natural resources that cause a community or groups within a community to lose access to resource usage where they have traditional or customary tenure or recognizable usage rights. This may include situations where legally designated protected areas, forests, biodiversity areas, or buffer zones are established in connection with the project. D. Relocation of people without formal, traditional, or recognizable usage rights who are occupying or utilizing land prior to a project-specific cut-off date. E. Displacement of people as a result of project impacts that render their land unusable or inaccessible. F. Restriction on access to land or use of other resources, including communal property and natural resources such as marine and aquatic resources, timber and non-timber forest products, fresh water, medicinal plants, hunting and gathering grounds, and grazing and cropping areas. G. Land rights or claims to land or resources relinquished by individuals or communities without full payment of compensation. And H. Land acquisition or land use restrictions occurring prior to the project, but which were undertaken or initiated in anticipation of or in preparation for the project. Paragraph 5. This environmental and social standard does not apply to impacts on incomes or livelihoods that are not a direct result of land acquisition or land use restrictions imposed by the project. Such impacts will be addressed in accordance with Environmental and Social Standard 1. Paragraph 6. This environmental and social standard does not apply to voluntary, legally recorded market transactions in which the seller is given a genuine opportunity to retain the land and to refuse to sell it, and is fully informed about available choices and their implications. However, where such voluntary land transactions may result in the displacement of persons other than the seller who occupy use of claim rights to the land in question, this environmental and social standard will apply. Paragraph 7. Where a project supports land titling or other activities intended to confirm, regularize, or determine land rights, a social, legal, and institutional assessment will be required under Environmental and Social Standard 1. The assessment aims to identify potential risks and impacts, as well as appropriate design measures to minimize and mitigate adverse economic and social impacts, especially those that affect poor and vulnerable groups. This environmental and social standard does not apply to disputes between private parties in land titling or related contexts. However, where persons are required to vacate land as a direct result of a project-supported determination that the land in question is state land, this environmental and social standard will apply, in addition to the relevant provisions of Environmental and Social Standard 1 mentioned above. Paragraph 8. This environmental and social standard does not apply to land use planning or the regulation of natural resources to promote their sustainability on a regional, national, or subnational level, including watershed management, groundwater management, fisheries management, and coastal zone management. Where a project supports such activities, the borrower will be required to conduct a social, legal, and institutional assessment under Environmental and Social Standard 1 in order to identify potential economic and social risks and impacts of the planning or regulation and appropriate measures to minimize and mitigate them, in particular, those that affect poor and vulnerable groups. Paragraph 9. This environmental and social standard does not apply to management of refugees from or persons internally displaced by natural disasters, conflict, crime, or violence. Requirements. A. General. Eligibility classification. Paragraph 10. Affected persons may be classified as persons A. who have formal legal rights to land or assets, B. who do not have formal legal rights to land or assets but have a claim to land or assets that is recognized or recognizable under national law, or C. who have no recognizable legal right or claim to the land or assets they occupy or use. The census described in paragraph 20 will establish the status of the affected persons. Project design. Paragraph 11. The borrower will demonstrate that involuntary land acquisition or restrictions on land use are limited to direct project requirements for clearly specified project purposes within a clearly specified period of time. The borrower will consider feasible alternative project designs to avoid or minimize land acquisition or restrictions on land use, especially where this would result in physical or economic displacement, while balancing environmental, social, and financial costs and benefits, and paying particular attention to gender impacts and impacts on the poor and vulnerable. Compensation and benefits for affected persons. Paragraph 12. When land acquisition or restrictions on land use, whether permanent or temporary, cannot be avoided, the borrower will offer affected persons compensation at replacement cost and other assistance as may be necessary to help them improve or at least restore their standards of living or livelihoods, subject to the provisions of paragraph 26 through 36 of this environmental and social standard. Paragraph 13. Compensation standards for categories of land and fixed assets will be disclosed and applied consistently. Compensation rates may be subject to upward adjustment where negotiation strategies are employed. In all cases, a clear basis for calculation of compensation will be documented and compensation distributed in accordance with transparent procedures. Paragraph 14. Where livelihoods of displaced persons are land-based or where land is collectively owned, the borrower will offer the displaced persons an option for replacement land in accordance with paragraph 35A, unless it can be demonstrated to the bank's satisfaction that equivalent replacement land is unavailable. As the nature and objectives of the project may allow, the borrower will also provide opportunities to displaced communities and persons to derive appropriate development benefits from the project. In the case of affected persons under paragraph 10C, resettlement assistance will be provided in lieu of compensation for land as described in paragraphs 29 and 34C. Paragraph 15. The borrower will take possession of acquired land and related assets only after compensation in accordance with this environmental and social standard has been made available with and where applicable, displaced people have been resettled and moving allowances have been provided to the displaced persons in addition to compensation. In addition, livelihood restoration and improvement programs will commence in a timely fashion in order to ensure that affected persons are sufficiently prepared to take advantage of alternative livelihood opportunities as the need to do so arises. Paragraph 16. In certain cases, there may be significant difficulties related to the payment of compensation to particular affected persons. For example, where repeated efforts to contact absentee owners have failed, where project affected persons have rejected compensation that has been offered to them in accordance with the approved plan, or where competing claims to the ownership of lands or assets are subject to lengthy legal proceedings. On an exceptional basis, with prior agreement of the bank, and where the borrower demonstrates that all reasonable efforts to resolve such matters have been taken, the borrower may deposit compensation funds as required by the plan, plus a reasonable additional amount for contingencies, into an interest-bearing escrow or other deposit account and proceed with the relevant project activities. Compensation placed in escrow will be made available to eligible persons in a timely manner as issues are resolved. Community engagement. Paragraph 17. The borrower will engage with affected communities, including host communities, through the process of stakeholder engagement described in Environmental and Social Standard 10. Decision-making processes related to resettlement and livelihood restoration will include options and alternatives from which affected persons may choose. Disclosure of relevant information and meaningful participation of affected communities and persons will take place during the consideration of alternative project designs referred to in paragraph 11, and thereafter throughout the planning, implementation, monitoring, and evaluation of the compensation process, livelihood restoration activities, and relocation process. Additional provisions apply to consultations with displaced indigenous peoples in accordance with Environmental and Social Standard 7. Paragraph 18. The consultation process should ensure that women's perspectives are obtained and their interests factored into all aspects of resettlement planning and implementation. Addressing livelihood impacts may require intra-household analysis in cases where women's and men's livelihoods are affected differently. Women's and men's preferences in terms of compensation mechanisms, such as replacement land or alternative access to natural resources rather than in cash, should be explored. Grievance mechanism. Paragraph 19. The borrower will ensure that a grievance mechanism for the project is in place, in accordance with Environmental and Social Standard 10, as early as possible in project development to address specific concerns about compensation, relocation, or livelihood restoration measures raised by displaced persons or others in a timely fashion. Where possible, such grievance mechanisms will utilize existing formal or informal grievance mechanisms suitable for project purposes, supplemented as needed with project-specific arrangements designed to resolve disputes in an impartial manner. Planning and implementation. Paragraph 20. Where land acquisition or restrictions on land use are unavoidable, the borrower will, as part of the environmental and social assessment, conduct a census to identify the persons who will be affected by the project, to establish an inventory of land and assets to be affected, to determine who will be eligible for compensation and assistance, and to discourage ineligible persons, such as opportunistic settlers, from claiming benefits. The social assessment will also address the claims of communities or groups who, for valid reasons, may not be present in the project area during the time of the census, such as seasonal resource users. In conjunction with the census, the borrower will establish a cutoff date for eligibility. Information regarding the cutoff date will be well documented and will be disseminated throughout the project area at regular intervals in written and, as appropriate, non-written forms and in relevant local languages. This will include posted warnings that persons settling in the project area after the cutoff date may be subject to removal. Paragraph 21. To address the issues identified in the environmental and social assessment, the borrower will prepare a plan proportionate to the risks and impacts associated with the project. A. For projects with minor land acquisition or restrictions on land use, as a result of which there will be no significant impact on incomes or livelihoods, the plan will establish eligibility criteria for affected persons, set out procedures and standards for compensation, and incorporate arrangements for consultations, monitoring, and addressing grievances. B. For projects causing physical displacement, the plan will set out the additional measures relevant to relocation of affected persons. C. For projects involving economic displacement with significant impact on livelihoods or income generation, the plan will set out the additional measures relating to livelihood improvement or restoration. And D. For projects that may impose changes in land use that restrict access to resources in legally designated parks or protected areas or other common property resources on which local people may depend for livelihood purposes, the plan will establish a participatory process for determining appropriate restrictions on use and set out the mitigation measures to address adverse impacts on livelihoods that may result from such restrictions. Paragraph 22. The borrower's plan will establish the roles and responsibilities relating to financing and implementation and include arrangements for contingency financing to meet unanticipated costs, as well as arrangements for timely and coordinated response to unforeseen circumstances impeding progress toward desired outcomes. The full costs of resettlement activities necessary to achieve the objectives of the project are included in the total costs of the project. The costs of resettlement, like the costs of other project activities, are treated as a charge against the economic benefits of the project, and any net benefits to resettlers as compared to the without project circumstances are added to the benefits stream of the project. Paragraph 23. The borrower will establish procedures to monitor and evaluate the implementation of the plan and will take corrective action as necessary during implementation to achieve the objectives of this environmental and social standard. The extent of monitoring activities will be proportionate to the project's risks and impacts. For all projects with significant involuntary resettlement impacts, the borrower will retain competent resettlement professionals to monitor the implementation of resettlement plans, design corrective actions as necessary, provide advice on compliance with this environmental and social standard, and produce periodic monitoring reports. Affected persons will be consulted during the monitoring process. Periodic monitoring reports will be prepared, and affected persons will be informed about monitoring results in a timely manner. Paragraph 24. Implementation of the borrower's plan will be considered completed when the adverse impacts of resettlement have been addressed in a manner that is consistent with the relevant plan as well as the objectives of this environmental and social standard. For all projects with significant involuntary resettlement impacts, the borrower will commission an external completion audit of the plan when all mitigation measures have been substantially completed. The completion audit will be undertaken by competent resettlement professionals, will assess whether livelihoods and living standards have been improved or at least restored, and, as necessary, will propose corrective actions to meet objectives not yet achieved. Paragraph 25. Where the likely nature or magnitude of the land acquisition or restrictions on land use related to a project with potential to cause physical and/or economic displacement is unknown during project preparation, the borrower will develop a framework establishing general principles and procedures compatible with this environmental and social standard. Once the individual project components are defined and the necessary information becomes available, such a framework will be expanded into one or more specific plans proportionate to potential risks and impacts. No physical and/or economic displacement will occur until plans required by this environmental and social standard have been finalized and approved by the bank. B. Displacement. Physical displacement. Paragraph 26. In the case of physical displacement, the borrower will develop a plan that covers, at a minimum, the applicable requirements of this environmental and social standard, regardless of the number of people affected. The plan will be designed to mitigate the negative impacts of displacement and, as warranted, to identify development opportunities. It will include a resettlement budget and implementation schedule and establish the entitlements of all categories of affected persons, including host communities. Particular attention will be paid to gender aspects and the needs of the poor and the vulnerable. The borrower will document all transactions to acquire land rights, provision of compensation, and other assistance associated with relocation activities. Paragraph 27. If people living in the project area are required to move to another location, the borrower will A. offer displaced persons choices among feasible resettlement options, including adequate replacement housing or cash compensation, and B. provide relocation assistance suited to the needs of each group of displaced persons. New resettlement sites will offer living conditions at least equivalent to those previously enjoyed or consistent with prevailing minimum codes or standards whichever set of standards is higher. If new resettlement sites are to be prepared, host communities will be consulted regarding planning options, and resettlement plans will ensure continued access, at least at existing levels or standards, for host communities to facilities and services. The displaced person's preferences with respect to relocating in pre-existing communities and groups will be respected wherever possible. Existing social and cultural institutions of the displaced persons and any host communities will be respected. Paragraph 28. In the case of physically displaced persons under paragraph 10A or B, the borrower will offer the choice of replacement property of equal or higher value with security of tenure, equivalent or better characteristics and advantages of location or cash compensation at replacement cost. Compensation in kind should be considered in lieu of cash. Paragraph 29. In the case of physically displaced persons under paragraph 10C, the borrower will provide arrangements to allow them to obtain adequate housing with security of tenure. Where these displaced persons own structures, the borrower will compensate them for the loss of assets other than land, such as dwellings and other improvements to the land at replacement cost. Based on consultation with such displaced persons, the borrower will provide relocation assistance in lieu of compensation for land sufficient for them to restore their standards of living at an adequate alternative site. Paragraph 30. The borrower is not required to compensate or assist those who encroach on the project area after the cut-off date for eligibility, provided the cut-off date has been clearly established and made public. Paragraph 31. The borrower will not resort to forced evictions of affected persons. Forced eviction is defined as the permanent or temporary removal against the will of individuals, families, and/or communities from the homes and/or land which they occupy without the provision of and access to appropriate forms of legal and other protection, including all applicable procedures and principles in this environmental and social standard. The exercise of eminent domain, compulsory acquisition, or similar powers by a borrower will not be considered to be forced eviction, providing it complies with the requirements of national law and the provisions of this environmental and social standard, and is conducted in a manner consistent with basic principles of due process, including provision of adequate advance notice, meaningful opportunities to lodge grievances and appeals, and avoidance of the use of unnecessary, disproportionate, or excessive force. Paragraph 32. As an alternative to displacement, the borrower may consider negotiating in situ land development arrangements by which those to be affected may elect to accept a partial loss of land or localized relocation in return for improvements that will increase the value of their property after development. Any person not wishing to participate will be allowed to opt instead for full compensation and other assistance as required in this environmental and social standard. Economic displacement. Paragraph 33. In the case of projects affecting livelihoods or income generation, the borrower's plan will include measures to allow affected persons to improve or at least restore their incomes or livelihoods. The plan will establish the entitlements of affected persons and all communities, paying particular attention to gender aspects and the needs of vulnerable segments of communities, and will ensure that these are provided in a transparent, consistent, and equitable manner. The plan will incorporate arrangements to monitor the effectiveness of livelihood measures during implementation, as well as evaluation once implementation is completed. The mitigation of economic displacement will be considered complete when the completion audit concludes that affected persons or communities have received all of the assistance for which they are eligible and have been provided with adequate opportunity to re-establish their livelihoods. Paragraph 34. economically displaced persons who face loss of assets or access to assets will be compensated for such loss at replacement cost. A. In cases where land acquisition or restrictions on land use affect commercial enterprises, affected business owners will be compensated for the cost of identifying a viable alternative location, for lost net income during the period of transition, for the cost of the transfer and reinstallation of the plant, machinery, or other equipment, and for re-establishing commercial activities. Affected employees will receive assistance for temporary loss of wages and, if necessary, assistance in identifying alternative employment opportunities. B. In cases affecting persons with legal rights or claims to land that are recognized or recognizable under national law, see paragraph 10A and B, replacement property, for example, agricultural or commercial sites, of equal or greater value will be provided, or, where appropriate, cash compensation at replacement cost. And C. Economically displaced persons who are without legally recognizable claims to land, see paragraph 10C, will be compensated for lost assets other than land, such as crops, irrigation infrastructure, and other improvements made to the land, at replacement cost. Additionally, the borrower will provide assistance in lieu of land compensation sufficient to provide such persons with an opportunity to re-establish livelihoods elsewhere. The borrower is not required to compensate or assist persons who encroach on the project area after the cutoff date for eligibility. Paragraph 35. Economically displaced persons will be provided opportunities to improve or at least restore their means of income earning capacity, production levels, and standards of living. A. For persons whose livelihoods are land-based, replacement land that has a combination of productive potential, locational advantages, and other factors at least equivalent to that being lost will be offered where feasible. B. For persons whose livelihoods are natural, resource-based, and where project-related restrictions on access envisaged in paragraph 4 apply, measures will be implemented to either allow continued access to affected resources or to provide access to alternative resources with equivalent livelihood earning potential and accessibility. Where common property resources are affected, benefits and compensation associated with restrictions on natural resource usage may be collective in nature. And C. If it is demonstrated that replacement land or resources are unavailable, the borrower will offer economically displaced persons options for alternative income earning opportunities, such as credit facilities, skills training, business startup assistance, employment opportunities, or cash assistance additional to compensation for assets. Cash assistance alone, however, frequently fails to provide affected persons with the productive means or skills to restore livelihoods. Paragraph 36. Transitional support will be provided as necessary to all economically displaced persons based on a reasonable estimate of the time required to restore their income earning capacity, production levels, and standards of living. C. Collaboration with other responsible agencies or subnational jurisdictions. Paragraph 37. The borrower will establish means of collaboration between the agency or entity responsible for project implementation and any other governmental agencies, subnational jurisdictions, or entities that are responsible for any aspects of land acquisition, resettlement planning, or provision of necessary assistance. In addition, where the capacity of other responsible agencies is limited, the borrower will actively support resettlement planning, implementation, and monitoring. If the procedures or standards of other responsible agencies do not meet the relevant requirements of this environmental and social standard, the borrower will prepare supplemental arrangements or provisions for inclusion in the resettlement plan to address identified shortcomings. The plan will also specify financial responsibilities for each of the agencies involved, appropriate timing and sequencing for implementation steps, and coordination arrangements for addressing financial contingencies or responding to unforeseen circumstances. D. Technical and financial assistance. Paragraph 38. The borrower may request technical assistance from the bank to strengthen borrower capacity or the capacity of other responsible agencies for resettlement planning, implementation, and monitoring. Such forms of assistance may include staff training, assistance in formulating new regulations or policies relating to land acquisition or other aspects of resettlement, financing for assessments or other investment costs associated with physical or economic displacement or other purposes. Paragraph 39. The borrower may request the bank to finance either a component of the main investment causing displacement and requiring resettlement, or a freestanding resettlement project with appropriate cross-conditionalities processed and implemented in parallel with the investment that causes the displacement. The borrower may request the bank to finance resettlement even though it's not financing the main investment that makes resettlement necessary. Environmental and Social Standard 5. Annex 1. Involuntary Resettlement Instruments. Paragraph 1. This annex describes the elements of the plans addressing physical and/or economic displacement described in paragraph 21 of Environmental and Social Standard 5. For purposes of this annex, these plans shall be referred to as resettlement plans. Resettlement plans include measures to address physical and/or economic displacement, depending on the nature of the impacts expected from a project. Projects may use alternative nomenclature depending on the scope of the resettlement plan. For example, where a project involves only economic displacement, the resettlement plan may be called a livelihood plan. Or where restrictions on access to legally designated perks and protected areas are involved, the plan may take the form of a process framework. This annex also describes the framework referred to in paragraph 25 of Environmental and Social Standard 5. A. Resettlement Plan. Paragraph 2. The scope of requirements and level of detail of the resettlement plan vary with the magnitude and complexity of resettlement. The plan is based on up-to-date and reliable information about A. the proposed project and its potential impact on the displaced persons and other adversely affected groups, B. appropriate and feasible mitigation measures, and C. the legal and institutional arrangements required for effective implementation of resettlement measures. Minimum elements of a resettlement plan. Paragraph 3. Description of the project. General description of the project and identification of the project area. Paragraph 4. Potential impacts. Identification of A. the project components or activities that give rise to displacement, explaining why the selected land must be acquired for use within the timeframe of the project. B. the zone of impact of such components or activities. C. the scope and scale of land acquisition and impacts on structures and other fixed assets. D. any project-imposed restrictions on use of or access to land or natural resources. E. alternatives considered to avoid or minimize displacement and why those were rejected. And F. the mechanisms established to minimize displacement to the extent possible during project implementation. Paragraph 5. Objectives. The main objectives of the resettlement program. Paragraph 6. Census survey and baseline socio-economic studies. The findings of a household-level census identifying and enumerating affected persons, and with the involvement of affected persons, surveying land structures and other fixed assets to be affected by the project. The census survey also serves other essential functions. A. Identifying characteristics of displaced households, including a description of production systems, labor, and household organization, and baseline information on livelihoods, including, as relevant, production levels and income derived from both formal and informal economic activities, and standards of living, including health status of the displaced population. B. Information on vulnerable groups or persons for whom special provisions may have to be made. C. Identifying public or community infrastructure, property, or services that may be affected. D. Providing a basis for the design of and budgeting for the resettlement program. E. In conjunction with establishment of a cutoff date, providing a basis for excluding ineligible people from compensation and resettlement assistance, and F. Establishing baseline conditions for monitoring and evaluation purposes. As the bank may deem relevant, additional studies on the following subjects may be required to supplement or inform the census survey. G. Land tenure and transfer systems, including an inventory of common property, natural resources from which people derive their livelihoods and sustenance, non-title based usufruct systems, including fishing, grazing, or use of forest areas, governed by local recognized land allocation mechanisms, and any issues raised by different tenure systems in the project area. H. The patterns of social interaction in the affected communities, including social networks and social support systems, and how they will be affected by the project. And I. Social and cultural characteristics of displaced communities, including a description of formal and informal institutions, for example, community organizations, reacher groups, non-governmental organizations, that may be relevant to the consultation strategy and to designing and implementing the resettlement activities. Paragraph 7. Legal framework. The findings of an analysis of the legal framework covering A. The scope of the power of compulsory acquisition and imposition of land use restriction and the nature of compensation associated with it in terms of both the valuation methodology and the timing of payment. B. The applicable legal and administrative procedures, including a description of the remedies available to displaced persons in the judicial process and the normal timeframe for such procedures, and any available grievance redress mechanisms that may be relevant to the project. C. Laws and regulations relating to the agencies responsible for implementing resettlement activities, and D. Gaps, if any, between local laws and practices covering compulsory acquisition, imposition of land use restrictions, and provision of resettlement measures, and Environmental and Social Standard 5, and the mechanisms to bridge such gaps. Paragraph 8. Institutional framework. The findings of an analysis of the institutional framework covering A. The identification of agencies responsible for resettlement activities and non-governmental organizations or civil society organizations that may have a role in project implementation, including providing support for displaced persons. B. An assessment of the institutional capacity of such agencies and non-governmental organizations or civil society organizations. And C. Any steps that are proposed to enhance the institutional capacity of agencies and non-governmental organizations or civil society organizations responsible for resettlement implementation. Paragraph 9. Eligibility. Definition of displaced persons and criteria for determining their eligibility for compensation and other resettlement assistance, including relevant cutoff dates. Paragraph 10. Valuation of and compensation for losses. The methodology to be used in valuing losses to determine their replacement cost, and a description of the proposed types and levels of compensation for land, natural resources, and other assets under local law, and such supplementary measures as are necessary to achieve replacement cost for them. Paragraph 11. Community participation. Involvement of displaced persons, including host communities where relevant. A description of the strategy for consultation with and participation of displaced persons in the design and implementation of the resettlement activities. B a summary of the views expressed and how these views were taken into account in preparing the resettlement plan. C a review of the resettlement alternatives presented and the choices made by displaced persons regarding options available to them. And D institutionalized arrangements by which displaced people can communicate their concerns to project authorities throughout planning and implementation, and measures to ensure that such vulnerable groups as Indigenous people, ethnic minorities, the landless, and women are adequately represented. Paragraph 12. Implementation schedule. An implementation schedule providing anticipated dates for displacement and estimated initiation and completion dates for all resettlement plan activities. The schedule should indicate how the resettlement activities are linked to the implementation of the overall project. Paragraph 13. Costs and budget. Tables showing categorized cost estimates for all resettlement activities, including allowances for inflation, population growth, and other contingencies, timetables for expenditures, sources of funds, and arrangements for timely flow of funds and funding for resettlement, if any, in areas outside the jurisdiction of the implementing agencies. Paragraph 14. Grievance redress mechanism. The plan describes affordable and accessible procedures for third-party settlement of disputes arising from displacement or resettlement. Such grievance mechanisms should take into account the availability of judicial recourse and community and traditional dispute settlement mechanisms. Paragraph 15. Monitoring and evaluation. Arrangements for monitoring of displacement and resettlement activities by the implementing agency, supplemented by third-party monitors as considered appropriate by the bank, to ensure complete and objective information, performance monitoring indicators to measure inputs, outputs, and outcomes for resettlement activities, involvement of the displaced persons in the monitoring process, evaluation of results for a reasonable period after all resettlement activities have been completed, using the results of resettlement monitoring to guide subsequent implementation. Paragraph 16. Arrangements for adaptive management. The plan should include provisions for adapting resettlement implementation in response to unanticipated changes in project conditions or unanticipated obstacles to achieving satisfactory resettlement outcomes. Additional planning requirements where resettlement involves physical displacement. Paragraph 17. When project circumstances require the physical relocation of residents or businesses, resettlement plans require additional information and planning elements. Additional requirements include Paragraph 18. Transitional assistance. The plan describes assistance to be provided for relocation of household members and their possessions or business equipment and inventory. The plan describes any additional assistance to be provided for households choosing cash compensation and securing their own replacement housing, including construction of new housing. If planned relocation sites for residences or businesses are not ready for occupancy at the time of physical displacement, the plan establishes a transitional allowance sufficient to meet temporary rental expenses and other costs until occupancy is available. Paragraph 19. Site selection, site preparation, and relocation. When planned relocation sites are to be prepared, the resettlement plan describes the alternative relocation sites considered and explains sites selected covering A. Institutional and technical arrangements for identifying and preparing relocation sites, whether rural or urban, for which a combination of productive potential, locational advantages, and other factors is better or at least comparable to the advantages of the old sites, with an estimate of the time needed to acquire and transfer land and ancillary resources. B. Identification and consideration of opportunities to improve local living standards by supplemental investment or through establishment of project benefit sharing arrangements in infrastructure, facilities, or services. C. Any measures necessary to prevent land speculation or influx of ineligible persons at the selected sites. D. Procedures for physical relocation under the project, including timetables for site preparation and transfer. And E. Legal arrangements for regularizing tenure and transferring titles to those resettled, including provision of security of tenure for those previously lacking full legal rights to land or structures. Paragraph 20. Housing, infrastructure, and social services. Plans to provide or to finance local community provision of housing, infrastructure, for example, water, supply, feeder roads, and social services, for example, schools, health services. Plans to maintain or provide a comparable level of services to host populations. Any necessary site development, engineering, and architectural designs for these facilities. Paragraph 21. Environmental protection and management. A description of the boundaries of the planned relocation sites and an assessment of the environmental impacts of the proposed resettlement and measures to mitigate and manage these impacts, coordinated as appropriate with the environmental assessment of the main investment requiring the resettlement. Paragraph 22. Consultation on relocation arrangements. The plan describes methods of consultation with physically displaced persons on their preferences regarding relocation alternatives available to them, including, as relevant, choices related to forms of compensation and transitional assistance, to relocating as individual households, families, or with pre-existing communities or kinship groups, to sustaining existing patterns of group organization, and for relocation of or retaining access to cultural property, for example, places of worship, pilgrimage centers, cemeteries. Paragraph 23. Integration with host populations. Measures to mitigate the impact of planned relocation sites on any host communities, including A. Consultations with host communities and local governments. B. Arrangements for prompt tendering of any payment due the hosts for land or other assets provided in support of planned relocation sites. C. Arrangements for identifying and addressing any conflict that may arise between those resettled and host communities. And D. Any measures necessary to augment services, for example, education, water, health, and production services in host communities to meet increased demands upon them or to make them at least comparable to services available within planned relocation sites. Additional planning requirements where resettlement involves economic displacement. Paragraph 24. If land acquisition or restrictions on use of or access to land or natural resources may cause significant economic displacement, arrangements to provide displaced persons with sufficient opportunity to improve or at least restore their livelihoods are also incorporated into the resettlement plan or into a separate livelihoods improvement plan. These include Paragraph 25. Direct land replacement. For those with agricultural livelihoods, the resettlement plan provides for an option to receive replacement land of equivalent productive value or demonstrates that sufficient land of equivalent value is unavailable. Where replacement land is available, the plan describes methods and timing for its allocation to displaced persons. Paragraph 26. Loss of access to land or resources. For those whose livelihood is affected by loss of land or resource use or access, including common property resources, the resettlement plan describes means to obtain substitutes or alternative resources or otherwise provide support for alternative livelihoods. Paragraph 27. Support for alternative livelihoods. For all other categories of economically displaced persons, the resettlement plan describes feasible arrangements for obtaining employment or for establishing a business, including provision of relevant supplemental assistance, including skills training, credit, licenses or permits, or specialized equipment. As warranted, livelihood planning provides special assistance to women, minorities, or vulnerable groups who may be disadvantaged in securing alternative livelihoods. Paragraph 28. Consideration of economic development opportunities. The resettlement plan identifies and assesses any feasible opportunities to promote improved livelihoods as a result of resettlement processes. This may include, for example, preferential project employment arrangements, support for development of specialized products or markets, preferential commercial zoning and trading arrangements, or other measures. Where relevant, the plan should assess the feasibility of prospects for financial distributions to communities or directly to displaced persons through establishment of project-based benefit sharing arrangements. Paragraph 29. Transitional support. The resettlement plan provides transitional support to those whose livelihoods will be disrupted. This may include payment for lost crops and lost natural resources, payment of lost profits for businesses, or payment of lost wages for employees affected by business relocation. The plan provides that the transitional support continues for the duration of the transition period. B. Resettlement framework. Paragraph 30. The purpose of the resettlement framework is to clarify resettlement principles, organizational arrangements, and design criteria to be applied to sub-projects or project components to be prepared during project implementation. See Environmental and Social Standard 5, paragraph 25. Once the sub-project or individual project components are defined and the necessary information becomes available, such a framework will be expanded into a specific plan proportionate to potential risks and impacts. Project activities that will cause physical and/or economic displacement will not commence until such specific plans have been finalized and approved by the bank. Paragraph 31. The resettlement policy framework covers the following elements. A. A brief description of the project and components for which land acquisition and resettlement are required, and an explanation of why a resettlement policy framework rather than a resettlement plan is being prepared. B. Principles and objectives governing resettlement preparation and implementation. C. A description of the process for preparing and approving resettlement plans. D. Estimated displacement impacts and estimated numbers and categories of displaced persons to the extent feasible. E. Eligibility criteria for defining various categories of displaced persons. F. A legal framework reviewing the fit between borrower laws and regulations and bank policy requirements and measures proposed to bridge any gaps between them. G. Methods of valuing affected assets. H. Organizational procedures for delivery of compensation and other resettlement assistance, including for projects involving private sector intermediaries, the responsibilities of the financial intermediary, the government, and the private developer. I. A description of the implementation process linking resettlement implementation to civil works. J. A description of grievance redress mechanisms. K. A description of the arrangements for funding resettlement, including the preparation and review of cost estimates, the flow of funds, and contingency arrangements. L. A description of mechanisms for consultations with and participation of displaced persons in planning, implementation, and monitoring. And M. Arrangements for monitoring by the implementing agency and, if required, by third-party monitors. C. Process framework. Paragraph 32. A process framework is prepared when bank-supported projects may cause restrictions in access to natural resources in legally designated parks and protected areas. The purpose of the process framework is to establish a process by which members of potentially affected communities participate in design of project components, determination of measures necessary to achieve the objectives of this environmental and social standard, and implementation and monitoring of relevant project activities. Paragraph 33. Specifically, the process framework describes participatory processes by which the following activities will be accomplished. A. Project components will be prepared and implemented. The document should briefly describe the project and components or activities that may involve new or more stringent restrictions on natural resource use. It should also describe the process by which potentially displaced persons participate in project design. B. Criteria for eligibility of affected persons will be determined. The document should establish that potentially affected communities will be involved in identifying any adverse impacts, assessing of the significance of impacts, and establishing of the criteria for eligibility for any mitigating or compensating measures necessary. C. Measures to assist affected persons in their efforts to improve their livelihoods or restore them in real terms to pre-displacement levels while maintaining the sustainability of the park or protected area will be identified. The document should describe methods and procedures by which communities will identify and choose potential mitigating or compensating measures to be provided to those adversely affected, and procedures by which adversely affected community members will decide among the options available to them. D. Potential conflicts or grievances within or between affected communities will be resolved. The document should describe the process for resolving disputes relating to resource use restrictions that may arise between or among affected communities, and grievances that may arise from members of communities who are dissatisfied with the eligibility criteria, community planning measures, or actual implementation. Additionally, the process framework should describe arrangements relating to the following. E. Administrative and legal procedures. The document should review agreements reached regarding the process approach with relevant administrative jurisdictions and line ministries, including clear delineation for administrative and financial responsibilities under the project. F. Monitoring arrangements. The document should review arrangements for participatory monitoring of project activities as they relate to beneficial and adverse impact on persons within the project impact area, and for monitoring the effectiveness of measures taken to improve or at a minimum restore incomes, livelihoods, and living standards.